All right. Hear ye. The Honorable Court of Appeals now is in session.
Good morning, please be seated. We are back on June 10th, 2026 for the 10:45 a.m. docket. The first case that we have scheduled this morning is Peter Ross versus BERDYCK. For appellant, we have Mr. Ross. Good morning. And for appellee, we have BERDYCK appearing via video conferencing. Can you hear us, Mr. BERDYCK?
Yes, I can.
We will go ahead and get started. Mr. Ross, have you already had a report before?
No, but I'm familiar.
Okay, so you'll get 15 minutes total in your presentation. You can argue, you can take a certain amount of time, argue in the beginning, and reserve part of that 15 minutes to argue
Rebuttal.
After Mr. BERDYCK. Would you like to reserve any time?
4 minutes.
4 minutes. Okay. I will help you keep track of that time. You will see though when you approach that you have time clocks, so that you will know how much time you use and how much time you have remaining for your rebuttal.
Okay.
Please approach and begin when you're ready.
Okay. May it please the court, I am Peter John Ross, appellant, appearing here pro se. This appeal presents a binary question of law that this court reviews de novo. Did appellee's April 22nd, 2025 filings comply with Civil Rule 11? They did not. They lack both a signature on the motion itself and the mandatory contact block. Once that threshold is determined, the rest of the lower court's rulings collapse as a matter of law. Certified mail was completed in September 2024 at record 95 to the address on appellee's then valid driver's license. The trial court dismissed the case in October 2025 for lack of personal jurisdiction and failure to perfect service under Civil Rule 3A. But it reached that conclusion by relying on appellee's April 22nd filings that should have been ruled non-compliant under Civil Rule 11. The court's decision to give dispositive weight to unsigned contactless filings was an abuse of discretion. Lukinas v. Roto-Rooter and Robinson v. Lorraine confirms that unsigned filings fail Civil Rule 11's accountability requirement and cannot be treated as a valid Civil Rule compliant filing. Civil Rule 11 gives the court discretion on whether to formally strike a defective filing. A lot of weight is given to the phrase may strike as opposed to being mandatory, but the word may goes to the remedy of striking, not to whether the filing complied with Civil Rule 11 in the first place. Compliance is a question of law. An unsigned motion without the mandatory contact block is not compliant simply because the court did not strike it. The court may have discretion over the remedy, but it has no discretion over the definition of that compliance. Civil Rule 11 is mandatory to ensure accountability. In a case where service is the central dispute, it is fundamentally unfair for the court to credit filings that omitted requiring contact information while using those same filings to undo service. I raised the Civil Rule 11 defects at record 3352 and 3387. The court never ruled on those or prior motions to strike, yet it relied on the defective filings to deny default and drive the service and jurisdiction outcome. The court made no mention of the defects or motions to strike and gave no explanation why the defects were harmless under Civil Rule 61. Because the April 22nd filings were explicitly cited to overturn service and dismiss the case, the prejudice was apparent. The court's acceptance of defects was arbitrary. At record 97, the court denied one of my motions for a technical defect. At record 217, the court strictly denied my motion to appoint a process server and a motion for service via publication, and even noted it as not well taken. The lower court demanded procedural perfection from me, yet that same standard vanished for the appellee, even though we are both pro se. This inconsistent enforcement of mandatory rules is additional abuse of discretion. The trial court's waiver analysis in the dismissal depends entirely on the April 22nd filing being a valid preservation. If April 22nd is not Civil Rule compliant and could not preserve the defense, then Ackman does not apply. Remove the April 22nd filings and certified mail service remains unrebutted on the record. Appellee's later merits participation also waives the defense, and no answer was ever filed. Appellee's first valid filing with both a Civil Rule 11 signature and contact block was his motion to compel on May 29 at record 2509. That filing did not preserve the service defense. Default judgment would have attached under Civil Rule 55A if the court agrees that the service defense was not preserved or it was waived. Even under track 2 from my brief, Appellee's June 8th filing was unsworn, lacked the required contact block, and included no affidavit authenticating its exhibits. Whether the June 8th filing complied with Civil Rule 11's contact information requirements is also a question of law reviewed de novo. Crediting the June 8th filing and exhibits in the June 16 ruling to overturn completed service and deny the motion for default, it's an independent abuse of discretion that also supports reversal. Compounding the problem, the April 22nd filings contained repeated personal attacks and scandalous allegations without any evidence. I filed timely motions to strike that inflammatory material. The court never ruled on those motions, never addressed the scandalous conduct, and instead used those same defective and abusive filings to reach an outcome determinative ruling, which is a due process violation. Accordingly, I respectfully request this court reverse the dismissal and enter default judgment under Appellate Rule 12, or alternatively, remand with instructions to enter default judgment. At a minimum, the court should remand with instruction to rule on the case without relying on non-complaint filings. Thank you.
I still follow.
You have had 10 minutes time to vote.
Thank you.
Mr. Burdick, you can give your presentation. Give it up.
I don't have a lot of complex legalese to give you. I was dragged into this case.
Then
I believe that if service was perfected, that I could have easily won the case. And I made roughly 200 public offers to accept service in the Bay Area, which I'm only currently about 75 miles away from. If you told me to be in the Bay Area, I could be there probably an hour and a half. Rather than take my public offers for service, he went into this. And when I make my filing motion to dismiss, I had no real legal experience as far as legal filing. So you can see as you look throughout the docket, the filings are getting better and better and better. There's numbers on pages. I'm becoming more adept at managing the case. And so what I know about the law is that any defects that he's referencing in the filing that the judge made, the one where she overturned service, any defects were cured when she made that decision. The appellant had the opportunity for approximately 8 solid months to contact the processor, send them to San Francisco, where I fully agreed publicly that I would meet them and set it up. There's reasons for that. Due to harassment from this particular process server that he attempted to appoint, who you will also note that their name is a television character read from the blacklist, which is one of the reasons that this process server was not appointed. And the fact that he's in Florida and I'm in California. Mr. Ross requests a default judgment. And the default judgment, I stand to lose substantive rights. Taking ownership of my social media with 90,000 followers and 100 million readers a year, which has virtually no content on them published on them. Taking my organization, toxicwastsites.org, taking away my constitutional right to publish controversial information about the EPA superfund. This was all a ruse. It states in my filing to essentially to repeat what I've written It's not challenge the actual basis of the trial court's dismissal to arrest permanent or civil. Rule 11 complaints, 3 misrepresents his availability for service, or it mischaracterizes state service, attempts intelligence. On that note, mistrust process. He did hire a process to run the bears and 600 miles south when he knew he was attempting to give the appearance of good faith service so that later he could argue for a default judgment based on that good faith service.
And it can be that over.
This case, to me, no matter how you rule, the default judgment is unconstitutional, period. 2, he's obsessed over minor defects. So, for example, your honors, you issue a ruling and there was only one signature on that page. Not both pages were signed, and that's what he's obsessing over in this case, is the fact that one thing is signed, but the next page is not. So these are very, very. Later in the case, when I filed for a motion, I filed to amend so that I can correct the title of the document that he objected to that.
Look at it. Well,
I believe, quite factually, that Judge Kimberly Feldcroft, who I had great respect for before I appeared before we were in this case, correctly, I think that as a matter of law, she was required to dismiss on August 28th. I think that Mr. Ross was given every chance to serve me. As you can see, I'm on a camping trip right now, just to the side. So I spent the summers in the mountains. I'm at the top of the Sierra Mountain right now. It's not easy for me to pack up $20,000 worth of gear and drive across the states so I can go meet somebody by August. I got tired of making public offers to accept service, which he refuses to do. And I just said, I'm not doing this anymore. And the judge dismissed the case. And so that's, I apologize if I'm stressed out right now. This case was, the initial case, this appeal were both filed exclusively for the purpose of harassment, of an excuse for people to stop me and search for me. I do believe, however, if you remain this to the lower court, order the judge to actually have him trial the whole thing in about 1 day. So there was never a question of whether or not I could win the case. I have no reason to dodge service, although I publicly endured now 18 months of public allegations of dodging service that I never dodged, which of course costs the public to hunt for me. If you could, with 100 million views a year, I'm a high-profile person, and so I get every crazy person on earth that comes after me on the internet. They get to his content, next thing you know, I'm stalking the victim every day of my life from a different person. And it goes on every day, all day. Again, I'm sorry for my stress, but you can see I've been traumatized by this man's actions. I have PTSD, I'm sorry. That's really all I have to say at this point. He can say whatever he wants. I believe that what I wrote in this stands, I believe the judge did a good job. Just if I have in there that literally says, I don't care if I'm serving this case or not. Just somebody make a decision so we don't work to it. Thank you.
Thank you, Mr. Rivett. Okay.
Claire, prevent.
You have 10 minutes on the call.
That was mostly merits and didn't offer much about the actual appeal. Let's start with the appellee just confirmed that the documents in question were defective. He said specifically that the judge cured the defects, saying there are defects to his filings. So that principal point is he's not even disagreeing with that. And also, he's also stating contradicting his own appellee brief where he said there was no harmless error. He specifically stated that the judge relied on the defective documents. Beyond that, I want to make sure I state this, is his due process rights are not affected. First, he was properly served to the address on his then valid driver's license. He never chose to file an answer. Even his later merits-based participation in the case, if you remove April 22nd and or June 8th, he waived participation. He never filed an answer. The only result should be default judgment on the record. He's also said it was minor defects. Missing a signature on the motion is not a minor defect. That's the whole level of accountability. As a hypothetical, if he were to be held in contempt for some of the scandalous things he said in those same filings, he could say, you can't hold me in contempt, there's no signature. I know that's hypothetical, but that's why a signature is relevant. Nonetheless, we're talking about service, and he was not providing the required address block. That's part of why it's required, is so that he can be held accountable, so that he can be reachable by the court. But the other interesting thing is he brought up numerous social media Bay Area offers to accept service. It's a logical fallacy because it's too vague to say, I'm willing to accept service somewhere in the Bay Area. That's roughly 800 square miles. There's that, but also it's a logical fallacy because he never waived service. If he says he can win on the merits, he had every opportunity the entire time to waive service and participate on the merits. So it's disingenuous for him to present that as some magical way of getting out of claiming he was both not served but was willing to be served but wouldn't waive service. It just doesn't make sense to me. And again, there's essentially three paths that lead to default judgment. If you remove April 22nd, either version of the file, because strangely he submitted 2 drafts, the next day withdrew one, but the court never made a distinction as to which version of that April 22nd filing that they relied on. So we don't even know which one it was. The trial court also, they made no mention of the motions to strike, the scandalous nature, anything about the Civil Rule 11 defects. They gave us nothing to reason why these filings were acceptable in the first place. So to me, this whole case seems problematic at best. And I think that there's a clear path to default with you remove the April 22nd filing, when you review de novo, on its face, there's no signature on the motion and no address block on, or contact block on the motion or the certificate of service. So it's not a minor mistake when there's 3 fairly big mistakes on the document, and that's both drafts. Once you remove that, there's no preservation of the service defense. So his merits-based participation waived, never filed an answer. The motion for default should have been granted. If you remove it, there's nothing contesting the original certified mail service. Therefore, again, no answer, motion for default, default should have been entered. Then if you just look at June 8th, that lacked the contact block, and the fact that all the evidence was not competent evidence with no notary, no affidavit, nothing that would be required to use that evidence to overturn service, then again, default judgment should have been entered. No answer was ever filed. That's pretty much all I have, I'm sorry. Any questions at all?
Thank you for your presentations this morning. Your case will be submitted and you will be notified of our decision in writing.
Thank you very much.